live here, and it should say we are there. So go ahead, Lori.
Okay, thanks. Well, welcome everyone to our special edition of a BIA meeting here on March 23rd. Thank you everyone for joining us, and thank you also for our special guests from Principles of Integrity for joining us as well. We're really happy to have you here tonight. Because it's a special meeting, we don't have a full agenda, so most of our meeting tonight will be the presentation from the folks at Principles. And but I will just run through a little bit about the agenda first, if you will. Is there anything we want to change on the agenda or add to the agenda before we get started and before we go through an approval? Doug, yep.
Thanks, Lori. Yeah, so basically what I would suggest is that we move Jeffrey and Janice up on the agenda so that they can do their presentation, and then after that, I guess we can do the approval of the budget. But also too, I would like an item added there. At the last council meeting, we discussed the opening of the retail outlets on statutory holidays, and so I just need a little bit of a discussion with you folks just to make sure that we're all on the same timeline as far as dates go, when these meetings are going to be and such. So 10 minutes for that at the end. So that's what I would suggest is let Jeffrey and Janice do their thing, and then we'll deal with the rest after. Okay.
Yeah, that sounds really reasonable. So let's add that in at new business at the end, if you don't mind,
Okay.
Kayla. Okay, and we're going to move the Integrity Commissioner presentation from number 5 right after approval of the minutes, so you guys can get right started. Okay, so that's the one thing. And I think the other thing we talked about was perhaps approving the budget for the BIA. That's another item that we'd like to add to the agenda tonight, right? So I'm not quite sure where to put that, Kayla, but if that goes under before new business, is that the budget discussion?
Sorry, yep, I have it listed as number 5, approval of the budget.
I'm sorry, I have an older version. Yeah, you're right. I have the previous version. I printed it out. Okay, yeah, no problem. So number 5 is the budget. So we'll talk about that as well. And I think, is there any other changes to the agenda for tonight? Jennifer's joined us. Thanks, Jen. So we've got Jen Yeague from the pharmacy and Linda Winter from the 100 Mile Store. Thanks for joining us as well. Okay, great. So let's go ahead then and approve the agenda. Do we have someone to make a motion to be it resolved that the Creemore BIA hereby approves this special meeting dated March 23rd, 2021 as presented? Do I have someone to make that motion and someone to second it? Doug and Jen. Hi, Jen. And all in favor? Okay, so that motion is carried. Thank you. Okay, so here's interesting. We are going to talk a lot about this tonight, but we always sort of go through this section of disclosure of pecuniary interest and the nature thereof. And that's where everybody sort of looks at their shoes and doesn't quite know what to say. So, so I think it'll be a really interesting part of our discussion, because that's exactly what we're going to talk about tonight. So does anybody first want to declare any conflict of interest, pecuniary interest at this time? Or maybe we'll wait and hear. Okay. Okay, so moving on, we're going to approve the minutes from last. Oh, do we have to do that, Kayla? Do we have to approve the minutes at this meeting? I guess we do. Okay. So what we need is a motion to approve the minutes from February 9th and March 9th as created by Kayla Reimer. Does someone want to make a motion to approve the last meeting's minutes? Did anyone read them? Doug? Do I have a seconder for the minutes from the last meeting? That was really from the AGM, actually. Jen will second it. Okay, and all in favor of the minutes from the last meeting? Great. Okay, thanks everyone. So that's carried. Great, so that's all our business taken care of at the front of the meeting. So now I'm happy to hand it over to Jeffrey and Janice, who some of us had the privilege of meeting a few years ago. I think Sarah joined me and Nancy back when you had one of these presentations at Clearview Township, and we were very lucky to be actually in the room with you then. So this is the second best thing, I suppose. So really interesting presentation and really important stuff for us on boards, because it's something, if we haven't been on a board before or we haven't done these types of things, you might not really understand it or really know what conflict of interest is, what pecuniary interest is, all these kinds of things. And I know it's been super, super interesting. And also, in full disclosure, myself, I've reached out to Jeffrey and Janice on a few occasions, and it's been really, really helpful just to make sure that, if you are going in a certain direction, you want to be able to make sure that, you're doing everything above board. And so I think it's important for all of us to know about the services that they provide. So with that, I'm going to hand it over to you guys. I don't know how you want to do it. Are you presenting to us with
We are, yes.
Okay, PowerPoint or?
Yeah, there's a PowerPoint. Thank you very much for that introduction. And while you can see us, I'm Jeff, that's Janice, somewhere else on your screen. I'll be starting the chat today. As I'm going to try and talk as I share my screen. See if this works. All right, that seems to work. I've lost you now. Okay, I can't see you any longer. Can you hear me?
Yes.
All
Yep.
right. So let me just adjust this. So I don't want to give away the whole story, but the good news is you won't have to pronounce the word pecuniary anymore at the beginning of the meeting, and we'll save that thunder for a little bit. It was music to our ears to hear that you find this sort of thing the most valuable, the work we do in providing education and training as well as advice. That is the most important part of being an integrity commissioner. We think it's the most valuable part for our municipal clients. Though most people perceive of integrity commissioners as, the cop or the sheriff that rides into town, we see ourselves more like coaches and teachers. And so, well, class, let's begin. We don't have a large group today. And so we invite you to interrupt and ask your questions. I'm hoping I can somehow, okay, I've got the screen back, excellent. I can see some of you anyways now. Interrupt, ask a question. It'll be our job to get through the deck. And we'll take those questions and follow whatever threads you want us to follow. And in fact, what we hope to cover today is this, just in a broad sense. There was training provided way back in April of 2019. That was a code of conduct refresher. We're not going to spend a lot of time on the conduct part of codes of conduct tonight. I mean, for the most, we're going to do a little bit, but for the most part, for boards such as yourselves, not really a need for focus unless there's some concerning situations. We'll cover the highlights and of course are open to discuss any aspect of the code of conduct. You'll see a table of contents just to remind you what codes of conduct cover. But most of our chat tonight is designed to provide some context and also to talk about the avoidance of conflicts of interest. And so we're going to talk about what the statute says, what the common law says, and what we think is your most common exception being the interest in common exception for a BIA. So the introduction, perhaps it's not really needed, but I did tell you a little bit about our approach to things. We see ourselves as coaches and teachers, and that's really fundamentally important to us. Janice and I come from the municipal sector. I'll let Janice introduce herself in just a second, but I was a municipal lawyer and then I was a municipal clerk, and worked with Janice at the city of Vaughan better than a decade ago, where we helped put together one of the first codes of conduct in Ontario. Followed some models, but we netted one together. And we also had an integrity commissioner. So we have experience being on the receiving end of integrity commissioner services. We like to say we were consumers of integrity commissioner services before we were providers of integrity commissioner services. And that does give us a bit of a different and a very rich perspective on what the role is, what our purpose is, and really what your purpose is as an appointed body working for the municipality. Janice, how about you? What's your background?
Sure. So yes, I'm also a municipal lawyer, and I spent, again, like Jeff, my whole career in the municipal sector. with the province and then 4 different municipalities, and ended up the city solicitor in charge of a large legal department reporting to council. And so in that role, one of the things that happens frequently is you get buttonholed at the last minute just before a meeting by members as to what should they do. Here's a circumstance they weren't aware of, something's on the agenda, etc. So you end up in those kinds of roles becoming very familiar with these rules. And even though in that role, it's not your obligation to provide that advice, you do try to always steer the elected officials and the appointees in the right direction. So we've kind of been steeped in this area for, the better part of 3 decades. So having said that, we have over the last 4 years really focused on providing integrity commissioner services to municipalities, small and large, and their boards across Ontario.
So
And I need to tell the one thing that Jeff likes me to make sure I note. I once was also an elected official, although you are appointees and not elected. I have had sort of firsthand experience on the other side of the table as an elected official. I was a school board trustee from 91 to 94 with the Peel Board. So that gave me a very firsthand insights into the trials and tribulations of actually serving in that capacity. And I think it gave me a better understanding. So we try to recognize and empathize a great deal with what members are sometimes experiencing.
we have a mantra, the principles integrity mantra. It's our operating philosophy. And I'll just paraphrase. It's really important to us because it guides us in everything we do. To paraphrase it, it suggests that from the perspective of the general public, all elected and appointed officials are somehow substandard in terms of their ethical wherewithal. And unfortunately, everybody is painted with the same brush. You're all Donald Trump as far as some members of the public are concerned. And unfortunately, we're starting from behind the starting line in terms of the perception of ethical integrity. And so the primary objective of having an integrity commissioner is to raise the public's perception that you and the elected officials are operating with integrity. And how do you do that? You do that by having a code of conduct and other policies that provide good governance and speak to proper ethical behavior. You do that by reaching out as required, as you need to, for advice, taking education like today, and having available an independent person who can receive complaints, resolve complaints if necessary, fully investigate them and report out on them. And so that describes the broad range of functions of an integrity commissioner. It's quite astonishing how broad our functions are, because we can do all of that. We can consult, provide advice on what kinds of codes should be adopted and other policies, right through to receiving complaints and so sorting out and settling complaints. And if not, having the discretion to fully review a matter. We have statutory powers to compel people to talk to us, that sort of thing, and ultimately report out and make recommendations for sanctions as appropriate. Very broad range of functions. We exercise them so as again as coaches and teachers, because particularly with volunteers, and one of the sanctions available, one of the sanctions in the toolbox is recommending a loss of pay for up to 3 months for a breach that an elected official might make. 3 months obviously is a very high end, but it's a maximum of three months. And in the scheme of things, that's not a criminal sentence. It's not that nothing goes on your record. It's not of the same kind of sanction as you would experience in other lots of light. So like a teacher or a coach, we can make you run laps or do some push-ups, but we're here to encourage better behavior, and we with you want everybody to do better. And if we don't have to do an investigation, we're thrilled with it from that perspective. So it's important to us. We're just sharing it. You don't have to memorize it or anything, but it is what guides principles integrity and how we do our work. So some of you attended the code of conduct training, just a really high level refresher on codes of conduct. Every municipality, every local board needs to have one. There were some changes in the Municipal Act in 2019, which required that every municipality, every local board has to have access to one of us, to an integrity commissioner. And with those broad range of functions that I just explained. And as a member of a local board, and that's what the BIA is, it's a local board of the municipality, you have access to us. You have access to advice just like any other member of council might have access to. And under the statute, there are some features of our statutory role that you should be aware of, one of which is that to the extent you ask us a question, and the Municipal Act says it has to be in writing, but we can do this through email, a chat first and some email, something like that. To the extent you ask us for advice, and we answer that advice by giving you a written memorandum, or in some cases just an email back, and the facts remain the same, you follow the advice, then the advice is binding on us. So in other words, nobody can complain that you breached something if what you did was follow the advice of the Integrity Commissioner. And though the Municipal Conflict of Interest Act, which we're going to talk about in a bit, is a provincial statute, which is enforced ultimately by the courts. We have a role to play, but there is potential that a matter could go to the courts in egregious circumstances. The court's going to listen to you when you say, I was just following the advice of my Integrity Commissioner, here's the advice. So you can't impose a significant, can't impose a real sanction on me because all I was doing was following the advice of my Integrity Commissioner. So it's binding on us, and that's really important. We have a duty of confidentiality as well under the statute. So while Janice and I are both lawyers, we're not your lawyers. There's no privilege between us. That said, there's a statutory cloak of confidentiality. And so certainly when you ask for advice, we provide the advice. Nobody knows that it was you. Nobody knows what the advice was at the end of the day. We bill monthly, and our billings are anonymized. So at best, the clerk will know that there was some conflict advice given or some code advice given or something of that nature, but nothing more. And we undertake to hold the information as confidential, so nobody gets to know that you reached out and you got this particular piece of advice. And that's really important. It gives you confidence. Well, first of all, we want to build a relationship so you feel confident in us, that you know that we know our stuff and that we're available to provide you some relevant guidance, but also you have confidence to know that we're not going to be tattling to anybody about the advice we give. And the same in the extremely unlikely circumstances that you're going to be subject to a complaint. The same is true about the way we carry ourselves. Our interviews are confidential. That applies to you as well as us. If we interview you, you've got to keep it confidential as well. We do have a discretion if we report out to explain ourselves and to disclose otherwise confidential information if we feel it is important in order for the report to be understood. But we don't do a he said, she said. It's extremely rare that we do disclose confidential information in a report. We're also independent. So nobody gets to tell us, I'll put it that way, what advice we wish to give, how to conduct an investigation. It can't be in our arbitrary direction or controls. We are independent of the municipality as we carry out our work, and that is a statutory obligation when a municipality hires an integrity commissioner. That said, we were consumers of Integrity Commissioner services before we were providers of Integrity Commissioner services, and we work collaboratively. So, what does that mean? It means that by all means, ask us questions. We will put our hand and say, no, we can't talk about that, or this is territory which undermines our ability to be independent. But we're happy to work contextually with the municipality and with you and your staff. No questions so far? You're all remembering the other training. We're not going to spend a lot of time on this, but you are, as a BIA, a local board of the municipality. There is a very complex series of definitions as to what is and what isn't a local board under the Municipal Act. And if somebody tells you that they have the perfect definition, they can tell you without any doubt whether a body is or is not a local board. They're probably lying to you, because it is a very messy series of integrated definitions and exceptions. That said, I'm not a liar when I say you're a local board. You're clearly a local board of Clearview. And that means that you're subject to the code of conduct. That means you've got access to an integrity commissioner. That means that you can seek our advice. There are two kinds of local boards, roughly speaking. You're actually, it's a bit of a cheat because you're actually a third kind of local board. But we broadly divide them into adjudicative and non-adjudicative or advisory local boards. And the BIA is an operating board, but we lump it into the advisory, non-adjudicative local board. There are some additional requirements of an adjudicative local board, the community of adjustment, for example, with respect to gifts and that sort of thing, and who you can talk to in the course of the hearing. It's not relevant for our discussion tonight, but that's the case. And the code of conduct for local boards in Clearview is a blended one. So there's just a section or two that pertains to adjudicative boards. So generally speaking, advisory committees all work within a similar framework. And the first point on this list is an important one from us, and that is that in all respects, we have to recognize the primacy of council. So particularly with pure advisory committees and such, their job is, guess what, to advise and not to do. So advisory committees, generally speaking, do the heavy lifting. They do some research, they hear from the community, they have agendas, and they talk about things they want to recommend to council, generally speaking. And it's council's duty and obligation to hear those recommendations and make a decision. They don't have to follow them, but it's council, because council is prime. Council will make its best decision of applying all of the inputs and trade-offs that it considers necessary. You, as a BIA, are a managing board, so you actually have decision-making powers, quite obviously, within your jurisdiction. You know that, I'm sure at every meeting you make a decision or two, and you decide to hold events, you decide to recommend levies and that sort of thing. So you're a little bit different in that you're not making recommendations to council on a regular basis. You are at your meetings making decisions. So that said, but just contextually, if you have questions, we can discuss it more, but just putting you the BIA in a bit of the framework. So there you see a list of the adjudicative local boards. We don't have to spend time on that. I'm going to just zip through these slides, and you'll see why an adjudicative body is a bit different. They're holding hearings essentially and making decisions based upon two competing parties that are appearing in front of them. And when it says no role for council, it means that what I just said is quite true, that council can't tell an adjudicative body what it should decide. It's up to the adjudicative body to decide. So this slide really is when we present to members of adjudicative bodies, we remind them that they should not be seeking counsel from a member. They shouldn't be seeking direction from a member of council. Council itself, the whole council sets the policy framework, and it's usually staff who are best able to provide advice. Now, from time to time, a member of council will have a role to play in the hearing. That complicates the matter. But just generally speaking, for adjudicative bodies, it's important to remember that the decision is made within the box. So within the information that is shared from either party and presented to those members. So, whoops, where did I go? Role of the management board. They behave similarly, I suppose. You are obliged to hear and consider all relevant information. You each bring different um, expertise to the table. You to make reasoned decisions based on the information that's provided to you. On occasion, you need to engage counsel, make a recommendation to them to assist you with a program or budget matter or something of that nature. Councillor McKechnie is a council representative, so he's there to provide guidance, act as a liaison, in addition to whatever contributions he may have on a particular subject matter. You have a fiduciary interest. I don't know, one might say that all members, all elected officials have a fiduciary interest. But we do need to recognize that there's a political interest as well for members of council, less so for members of appointed bodies, but there is politics in everything. When we say fiduciary interest, it means you need to take care, particularly since you are managing contributions that are provided to you by your members, which are to be spent for the benefit of those members, for the BIA as a whole. And so, as members of the board, you must be alive to the potential that a conflict of interest exists for you, or potentially exists for you. We're going to talk more about that a bit. As I mentioned, we're not going to go through the code of conduct provisions unless you wish us to speak to anything in particular. But, practicing that golden rule works, right? Particularly with the behavioral type concerns. Treat others as you'd like to be treated yourself, or I'd like to have them treat you. Will go a long way. What does that really mean? It means to be non-disparaging, be respectful. Doesn't mean you can't disagree. Doesn't mean you can't be passionate about things. You really can't be disparaging of the person you're dealing with or somebody else, some third party who's not there. And you're going to get advice from the chair, from the clerk, from other staff who might be in attendance on how you can deal with those prickly situations and not be in violation of a consideration spoken to in the code of conduct. Now, I'm a former clerk, and you might think that as a clerk, I'd be really rules oriented, but not so much really. And so it's quite all right to be accommodating, be polite, but you have a role, so you can be firm as well if you're running a meeting. And it's really, if by giving an extra minute of speaking time, you avoid some real frictions, give the extra minute of speaking time, that sort of thing. So be accommodating, deal in the context. It's not just about applying the rule and rigidly so. If there is a problem, recess, ask for some advice, let temperatures cool, and come back to the matter. And when we say respect the institution, yes, you're part of the institution as a local board of the municipality. So you have to have respect for yourself. You have to have respect for the municipal organization as well. Again, that doesn't mean that you can't be critical. It means you should be constructively critical if you have a need to be critical. All right, we're getting closer to the Municipal Conflict of Interest Act. We're not quite there yet. I'm going to just borrow something from a little bit later in the presentation, and that's this. These 4 principles were embedded in the Municipal Conflict of Interest Act not too many years ago. I think it was 2017, if I'm not mistaken. And the first 3, members shall give the public and their constituents, shall serve in a conscientious and diligent manner. You might expect that in any kind of code-like document. Members of council should be committed to performing their functions with integrity, impartiality, and transparency. Sure, we all understand that. Members shall perform their duties in office, arrange their private affairs in a manner that promotes public confidence, absolutely, and will bear close public scrutiny. Now, close public scrutiny is actually a very high standard, but you get it, right? You would expect that in a statute like the Municipal Conflict of Interest Act or in a code of conduct, that those standards would exist. And we actually import these principles into the codes of conduct that we recommend our clients adopt, as has been done in this municipality. But that fourth principle is a bit interesting. It's curious because it says that there's a benefit to municipalities when members of the BIA or of council have a broad range of knowledge and continue to be active in their own communities. In a business, in a profession, in a community association, and something else, but that's a good thing, says the Municipal Conflict of Interest Act and says the Code of Conduct. So this really drives us to the discussion of conflict of interest because, I mean, at the beginning of today's meeting, you approved an agenda. And you would think the only reason the BIA exists is to serve the pecuniary interests of its members. That's the only reason you exist, is to encourage better business environment for your members. So one might say technically by approving the agenda or doing anything else in the course of a BIA meeting, every member of the board has a pecuniary interest. That would be absurd, though. I mean, we know that you exist. We know that you're encouraged to exist, and so that would be an absurd interpretation. And we like this principle because it helps us to say when providing advice or in examining a complaint, helps us say, well, wait a second. If this is about a conflict, it's got to be a likely conflict, a real conflict, not something that's potential, not something that's remote, not something that is really not actually contemplated when you set up a BIA. So the example we'll often give in training is this: the BIA is considering having a street festival, and of course every member of the BIA is going to benefit from this street festival, so you all participate and vote on it. But in the course of doing this design for the street festival, you want to provide some catering. And there's a restaurateur on the BIA. And so the board is discussing, there you go. And the board is discussing who's going to provide the catering contract. Is it OTA? Is that how I pronounce your name?
Yes.
OTA? OTA. So OTA is interested in this. He can't participate in the discussion because his interest here is a little different than everybody else's. And he's a direct interest in the catering contract. So for that, he has to step back. It's not a bad thing. In fact, it's a very good thing to recognize when you have an interest that must be a conflict in an interest that has to be avoided. So, and again, I'm on too close to Janice's territory here. So let me
Jeffrey,
just continue on. Sure.
Could I ask a question?
By all means.
In that context, when you say that person has to step back in the world of Zoom, what does that mean? Like, does that mean that they mute themselves or that they literally have to leave the meeting? Or I know in the past, like we've talked about people maybe leaving the room and stepping outside. What does that mean now?
So there are two rules. One is that when you have an interest, you have to step back, and Janice is going to go over this. She's going to repeat it. It's important. So hearing it twice isn't a bad thing. If you have an interest, whether, let's just say it's a municipal conflict of interest clarity at this point, you have an obligation to not influence the discussion or vote.
Right.
So clearly you can't vote on it, but you can't move it. And that influence can't occur before, during, or after, even after the meeting.
Okay.
So that means that you need to step back. So for a public discussion, we would encourage you to turn off your mic. It might be prudent just to turn off your camera to demonstrate that you're not participating in the discussion. And if you were in meeting in person, we'd suggest maybe just push back from the table and not participate, just to demonstrate that you're not part of that.
Okay.
We have heard advice given where people are asked to leave the room in a public discussion because it's fearful you might make a face or do something untoward. I mean, if you can't control yourself, maybe you should, but it's not necessary that you do that. In fact, you're entitled to listen to the discussion.
Okay.
And you're entitled to know when the discussion's coming to an end so you can get into the next one.
Okay,
So you,
that
you do
helps.
not, you do not have to leave, but you just can't influence. Okay, let me just finish this and then I'll come to the question, okay?
Yeah.
So that was part one. Part two is if your discussion happens to be in closed session. Okay, it's one of those legitimate Section 239 reasons where you can meet in the absence of the public. In that case, you must not be present. So if it's a private matter, a closed session matter, then what I just said about public meetings does not apply. You cannot be present. Okay. You had a question?
Yes. So the question is, so examples. So I've been sent this petition about, opening businesses in Ontario and small businesses, and because we also represent, the township and the council and everything. It's like, is that a conflict of interest for us to have an opinion that we want to participate in those kind of petitions, or like
So
it's a
I'm going to ask you to hold that question because we're going to give you some context for it first. Make sure we don't ignore you, but just pause
Yep.
for a bit if you don't mind, because we've got some context
Yep.
for you that will help with
Yep.
the answer. Okay.
Yep.
Okay. So let me just see. We're still on codes of conduct, and generally speaking, they're going to say, you've got to be diligent about doing your job. You got to show up and do your part at meetings, respect the role of everyone, including the chair, and your processes and procedures. As I mentioned, demonstrate respect, don't be disparaging, and do your due diligence. So you come to the table prepared for the meeting. And this should go without saying, and we pack all this into that golden rule sort of thing. You should be professional in your demeanor, abide by the transparency obligations of serving a public body, being accountable, adhere to the book, and all of that. As we say, by all means, be critical, but you need to be contributing constructively when you're engaging on matters. Now, I'll just, I come from the municipal sector. I've been in the municipal sector forever, and without word of a lie, including having been in the clerk's chair in places like Toronto, like big problematic at times municipalities. And I still marvel at how municipal meetings can start with people on all different sides of an issue. And through this really, at times, inefficient, sometimes ugly and messy process of deliberative democracy, more times than not, people come to a decent decision. Like the process works. And so your engaged contributions are really important. Even though you may think that you're an outlier or something, the stuff works. It's brilliant when people participate in it honestly and effectively and with some energy. So it's not a code violation for sure to disagree with somebody. It's the manner in which you communicate or question or point out flaws in an argument. Obviously, you as you're considering matters, you want to, yes, you need to be discriminating intelligently so, but you can't have bias. You can't be preferring one faction over another faction. And we're about to talk about avoiding real or apparent conflicts of interest. When we say bias, there's actually a legal concept of bias, and it's a cousin to conflict of interest. And it probably shows up every time you sit either in the BIA or you counselor in the chamber. You read the agenda, and you, having read it, you agree with the recommendation in the report. You walk into the meeting thinking you're going to vote for that thing. Are you biased? You have a predisposition to lean one way already, even before the meeting has started. Are you biased? Are we biased when we get a complaint and we read it and we say to ourselves, oh boy, if this is true, if these facts prove to be true, that's a violation of the code of conduct. Are we biased? No. The state of bias is that state where your mind is completely closed to change. So if you're curious about these things, you may well have a predisposition to vote in a certain way, but you're ready to hear your colleague's argument or staff's position or a deputation or input from a member or somebody like that. And so long as you are open to having your mind changed, you're not biased. You may still well vote the way you originally did, but so long as you're curious about what others might say and how that might change your thinking on the matter, you're good. It's not biased. So we usually mention that because we find that people find it helpful. I mentioned this a little earlier. We recognize that sometimes these training sessions sound like 1-800 call your integrity commissioner. But the fact of the matter is that an ounce of prevention is worth a ton. Sure. An hour of our time, we've seen questions, we serve over 40 municipalities and other public bodies across the province. So we've probably seen a version of your question before, and it takes us hardly any time, an hour or two max usually, to turn around a piece of advice for you, which is in terms of actual cost of a complaint or reputational damage or time or anything else is a bargain. And we would much prefer to be serving you through the occasional advice request than doing even a single investigation. So that's why this is here, to remind you that we are available, but also to protect you. You're bulletproof once we've provided you with that advice if there's a contentious issue. So this, I'll just give you a moment to look at this. This is the table of contents, as it were, of the Code of Conduct. A couple of provisions are blank because they don't apply to boards. What were they? Rule 3 is members' expenses, and Rule 14 is employment of relatives. So what we've done for our clients is we've written a Code of Conduct light for members of local boards. And it refers back to the parent Code of Conduct, which is Council's Code of Conduct. So this aligns with Council's Code of Conduct, with the exception of those two provisions which aren't relevant to the local board. And so it's hoping that you've read it. A very simple document. But for interpretive purposes, you can go back to our main code. And our main code is built, the design that Janice and I came up with well over a decade ago is the code, the parent code has commentary built in. Yours has a little commentary built in, and it's based on Janice and I both being lawyers, we borrowed from the design of the rules of professional conduct for lawyers, where there's a relatively few rules and then an explanation, commentary, so that it gives real world guidance to a person when they're trying to interpret the rule. So it remains educational. In any event, is there anything that anybody can think of now that you'd like to discuss before we move on? Fair enough. Obviously, if something comes to mind, ask. There's also a protocol for complaints and that sort of thing, and there's reference to the parent code there. So now I'm going to turn it over to Janice, and Janice, just wave or something when you want me to flip the slides. I'll keep the screen share.
So I'm going to talk to you about avoiding conflicts of interest. And I will go to the next slide and I'll jump right in. So historically, and really for about the past 30 years, the Municipal Conflict of Interest Act has been really considered the Bible or the source for identifying a conflict of interest. And so the MCIA does provide guidance. It's very specific as to what constitutes a pecuniary interest. And the key words under the Municipal Conflict of Interest Act are there's a pecuniary interest. And although it's not defined, everybody understands that that means financial interest. The Municipal Conflict of Interest Act, which we short form, we call it the MCIA. It's what most people in municipal councils talk about, the MCIA. it talks about and defines what is a direct interest of a member. So remembering that the MCIA, the Municipal Conflict of Interest Act, deals with members of council and members of local board. So when the act specifies members, it's really talking about members of council and appointees to local boards, including BIAs. So the act defines direct interests, it defines indirect interests, and it defines deemed interests. So these are really the statutory requirements, and we'll talk about those. But in a minute, we're going to also talk about the common law concept of conflict of interest, which, if you followed the recent Collingwood judicial inquiry, that's really getting into the common law conflict of interest. And it is broader. It exists. It's a feature in the common law, and it's often ignored by members because they have historically, for 3 decades, thought that they only had to look at what the statute, what the Municipal Conflict of Interest Act said. And in reality, there's a broader area. So we'll talk about that in a minute. Let's stick for a moment with the MCIA. The key elements under the MCIA, the Municipal Conflict of Interest Act, identify that a direct interest is when the member sitting on council or sitting on the body is considering a matter where their own personal financial interest is impacted. That's a direct interest. A deemed interest is where the member is sitting considering a matter that affects the interest of their parent, their child, or their spouse. That creates a deemed interest. So, and it could be a direct interest of the parent, child, or spouse, or it could be an indirect interest of the parent, child, or spouse. Now, just looking at that definition, so I'm digressing a little, that defines what a deemed interest is for the member. So if the member is looking at a matter that deals with the interest, direct or indirect, of their parent, child, or spouse, that member has a pecuniary interest. Who's missing from that list? And this is the statute. Who's missing from that? Parent, child, spouse, where's sibling? Right? So it's evident, even on the face of it, that there are gaps even in the legislation. And that's where the common law fills in those gaps. The common law has resulted from court decisions. So let's talk briefly about indirect interest, because they often arise, and we'll talk briefly about why. So an indirect interest is where the member sitting on the body is considering a matter where it's, let's say, a corporation, and they are a shareholder of that corporation, and it's a private company. Or they have a controlling interest of a publicly traded corporation. Now, that's not going to happen very often, because mostly people who have controlling interests in publicly traded corporations aren't sitting on these bodies. But the indirect interest, which is created where the member is a shareholder or an officer of a private company, that arises from time to time. Another indirect interest, is where the member is considering the matter, and the matter is of a pecuniary interest to the body that member's a member of. Too many words. It sounds too legalistic. Let's take an example where council is, I'll use council as an example, where council is considering whether it's going to give grants to a bunch of service clubs and other organizations once a year. Usually there's a list of those organizations who would like to have some support from their local council. If the member of council is also a member of that service organization, then the MCIA says that creates an indirect interest. And so that member, even though they may not have any particular benefit flowing from that, must declare a conflict of interest. Now, that's an unexpected outcome for a lot of elected officials. But it makes more sense, for example, if instead of a service club, one thinks of the local golf course. If the local golf course is a club and has a matter before council, let's say a redevelopment of 9 holes into subdivision, if the member on council is also a member of that golf club, that golf club has a pecuniary interest in that application going forward. So the member would have to declare an interest and step away. That's the indirect interest, which sometimes catches members by surprise. So, okay, let's go to the next slide.
Just before, because we don't have a slide on this, and given that example, Janice, so the Act also contains a number of exceptions, and we're going to be talking about one of them later. But if Councillor McKechnie was sitting at council when the BIA budget was being considered, the budget being obviously a pecuniary interest of the BIA, he would have an indirect interest being a member of the body, the BIA, while he's sitting at council. Fortunately, there's an exception. And one of the exceptions is that if you're appointed by council to the body, you don't have you're not in conflict by virtue of that appointment. So the Act contemplates a number of circumstances. We're going to be talking about one at a bit more length, but you've got the basics of it there.
Okay, so the conflicts of interest that are identified under the Municipal Conflict of Interest Act, and we've just talked about those, deemed indirect, direct, and the conflicts of interest that are identified under the common law, and we're going to talk about those in a minute. We have determined that it probably makes more sense to consider all of those conflicts of interest as disqualifying interests. And that's the kind of language that we've adopted into our code of conduct. And in fact, and we'll probably have a little talk on this later, that is the kind of language that the Collingwood Judicial Inquiry has recommended to the province, to talk about these as disqualifying interests, to adopt the same language that we have. In fact, they've recommended the provisions of our code of conduct to the province because it seems to capture it better for members. So if you look at the bucket on the left, that is the MCIA conflicts of interest as defined. So those are the direct, deemed, and indirect. So you can see it's my own interest, my parent, spouse, or child's interest, my employer's or a body that I belong to interest, or my company's interest. On the other side is the common law bucket. So common law conflicts of interest are identified through the jurisprudence, through a number of cases. And what they distill down to is that would the reasonable person, reasonably well informed, so it's not just somebody off the street, it's would the reasonably well informed person think that that was something which prevented the member from dealing with the matter completely impartially. So it becomes a question of the facts. The context becomes very important. So in that bucket, you can think of an interest that might give rise to a common law, a conflict of interest for the member under the common law would be a matter that might be the interest of your close friend or your associates, business associates, for example, or your own family's broader family, not just parent, child, or spouse, but a broader circle of family, perhaps grandparents, perhaps obviously sibling, grandchildren. It's a broader concept, and the common law has identified this. And then biases, and Jeff spoke about biases, but the kinds of biases that we typically see where somebody has a preference for something, as long as they're not closed-minded about hearing all of the issues. So, when we think about what is bias, bias is really, I don't care what you say, I'm doing X. That would convey a sense that their mind is closed, and that's a bias. I'm not going to spend any time really on that, but these two buckets combined, we consider these under our code of conduct to be disqualifying interests. These are things where members have to say, wait a minute, I have a disqualifying interest. I'm going to recuse myself from this matter. I'm not going to participate or try to influence it. And if it's enclosed, I'm going to leave the room or the Zoom. Okay, and I think I just covered that. So one of the things that I want to be sure I cover is in recognizing and dealing with conflicts of interest, there is an obligation to declare the nature of the interest. So it's not enough to say, I have a conflict of interest. There's actually an obligation to disclose the nature of the interest. I have an interest, that's my son-in-law's company or something like that. And as we say, if in doubt, seek some advice. Let's jump to the next slide. Okay, so this, we imported a small citation from the Collingwood Judicial Inquiry because it just came out in November. And it really does capture that the legislation, which is the Municipal Conflict of Interest Act, which has been the source for many municipal politicians over these years, it does not capture all of those conflicts of interest that members need to be aware of. And therefore, this recommendation to the province is, hey, amend the legislation to recognize so that members of council and members of boards don't get caught out unnecessarily with these conflicts of interest, disqualifying interests really, that are not specifically in the legislation. So, and this is the particular provision. So the province of Ontario should amend the Municipal Conflict of Interest Act to broaden its scope beyond deemed pecuniary interest to encompass any real, apparent, and potential conflict of interest. And because they're already captured in the common law, we already have judicial inquiries, at least two, where these kinds of interests have been spoken about. And members of council find themselves on the shoals of difficult situations because they're maybe taken unawares. So we always emphasize this in our training. This is key. It's that it's not just the MCIA, it is the disqualifying interests created by both the MCIA and the common law. So this is really the provision which the Collingwood Judicial Inquiry is urging that the province adopt into the legislation. We certainly have already promoted this definition to our municipal clients to adopt into their own codes of conduct. It may be that the province will simply require it through the Municipal Act that it be adopted into codes of conduct. We're not really sure where that's going. There is a current review right now by the province. So,
But I just want to add to that, Janice, if you don't mind, that the code of conduct that Justice Morocco was referencing was the code of conduct that Simcoe County adopted, and Simcoe County is also a client of ours, and it's the code of conduct that we recommend to our clients. It's the code that Clearview had already adopted for itself. So we're happy to see this alignment in our thinking. It might be concerning for you to know that not only do you need to know about the MCIA, but there is this whole thing called the common law that you're responsible for compliance with. But the good news is this. One is you've got access to the Integrity Commissioner. We see ourselves as the reasonable person. We apply that test, so we're able to help you find your way through the gray areas. And there's also a little tool that we created in that code of conduct called transparency disclosures. And Janice, I'm just doing it now because we didn't include it in this particular deck. Transparency disclosures. And so to the extent you've got somebody watching you in the community and ready to pounce on you, and you happen to have an interest in something that is not disqualifying, you can make a transparency disclosure. It's the flip side of the form used for declaring interests. And you're saying essentially, look, I have an interest, but it doesn't amount to a disqualifying interest. My interest is that I know this person as an acquaintance, but a reasonable person would not say that I cannot separate that relationship from my duty to the board to act impartially. And so I'm disclosing my interest, but I am going to participate, right? So it's not everything under the sun that attracts, or even though it's contemplatable that somebody could argue. You've got this relief valve to say, yes, the person is my next door neighbor, but we're not best friends. He's no different from anybody else on the street, and so I'm going to participate in this. We don't want the code to be a trap. The common law shouldn't be a trap. You should be quite capable of deciding for yourselves when you've got a concern. We're available to assist if it's a tricky situation, and we can bulletproof you. But this should all be perceived as a guide for you and for the board. Sorry, Janice, I'll give it
no,
back to you.
that's fine. Okay, so where are we at?
So
All
we've
right.
talked about these already.
Right. Interest in common. Do you want to talk about this, Jeff?
Sure.
Yeah.
So we've been hinting at this. It's probably the trickiest piece of advice we give because we have to make a call. But I mentioned other exceptions earlier. This is an exception under the Municipal Conflict of Interest Act, and we apply the same sort of reasoning when we look at common law interest concern. And what it means is this, that if you have an interest, let's start with members of council. The member of council has an interest that is the same as everybody else in the municipality, and that's called an interest in common. I think the best example of an interest in common is the tax rate. Every year, members of council have to decide on the budget, and likely is going to be an increase in the amount of property tax they and everybody else in the municipality has to pay, even if it's a smidgen. That's a pecuniary interest. But because their interest is the same as everybody else's, the same nature as everybody else's, the exception allows them to participate in the decision on the budget. And it's a good thing because, but for the exception, there'd be no budget. The municipality couldn't operate. So the general rule is when you have an interest in common with everybody in the municipality, electors generally have this interest in common, but the rule has evolved, so it does not have to be everybody. It needs to be a sufficient class of people, and this is why it's a judgment call on our part, sufficient class of people. But if your interest is the same as everybody else's interest in that class, then you're good to go. So, BIA. You all have the same interest. It may differ in degree, which is okay, can't differ in kind. but you would all have the same interest in a general uplift to the business community in Creemore, maybe even in Clearview. You have that in common, and so you can vote to approve the agenda. You can vote to have that street festival because your interest is an interest in common with electors generally. Using the example before, it's okay if it differs in degree, more in the council example, more or less property tax based on your frontage. That's okay. That doesn't kick you out of the interest in common exception, but a difference in kind would. So if in the council example, we're talking about a road repaving, we're going to hard top some road. And the road is 3 kilometers long with a whole lot of properties on it. That's big enough for an interest in common. So just be here, the hard topping is going to increase the value of every home alongside that road, but that's okay. It's determined to be an interest in common. But wait a second, in the course of doing this hard topping, the municipality needs to sneak in a widening here or there. And so there are 1 or 3 expropriations. One happens to be a member of council, or maybe a brother of a member of council. That's a difference in kind. And so the member no longer enjoys the interest in common exception. Janice, can you think of another example?
Well, I think the issue has arisen quite a bit in municipalities around Ontario recently, where often some of the COVID related business enhancing policies and programs for patios, outdoor patios, use of sidewalk have come into effect. And in those particular cases, it's not necessarily BIA specific. It's happened where members of council, there may be one member of council who has a particular, restaurant or bar or cafe or what have you. They have a particular retail business. The question arises if the idea of the business enhancing initiative is really in principle to lift all boats. Is that an interest in common? And when we look at that, we look at, well, does the particular member who has the particular retail who's going to really benefit differently than every other member of that organization, they're going to benefit specifically from, let's say, a patio that they are going to be able to expand their space, etc. Those become very specific interests to them that is different than the interest in common. So I guess that's the one example that we've seen a number of times. I mean, interest in common, it's a bit difficult sometimes to think of what is an interest in common, but I think it's Jeff explained it well. If the member's interest arises because of unique circumstances, it's arising because of their relationship with somebody else, or arises and is different both in nature and in kind, then it's unlikely to be an interest in common. Whereas if it arises simply because all of the it's a benefit to the entire BIA to be running a festival or a fall fair or something, then that type of a thing, it's much easier to see it as an interest in common.
So it's why we have those provincial principles in the embodied principles a couple of times in this presentation, because really nestles well with the interest in common exception. So the fourth principle says to us, it's a good thing to have people who are engaged in the business community to sit on a BIA board. So it's only where the interest is real and would interfere with the member's ability to participate partially in the discussion, or where it's technically, because we can do nothing with the statute, it's caught by a technical provision in the MCIA. We should be seeking out opportunities for members to participate, to do their job. And what we'll often do is say, the report can be segmented so a member can participate in this part of the discussion and not that part of the discussion.
I just want to, let me just circle back to the question that Otta had with respect to petition. And I think if I understood your question, you were saying, well, are you at liberty to sign on to a petition that's advocating a particular position that might be of benefit? I think you're a restaurateur. You're in the restaurant business? I can't, yeah, okay, so.
You can't see?
Yes, yes.
I couldn't hear. So, and I believe that you're asking, can you sign on to a petition that's going to be advocating for a particular perspective for the restaurant association or the restaurant?
Yeah.
And so here's how we would look at that. If the issue is going to come before the BIA in any way, and only, it seems to me unlikely, but let's assume for the sake of answering that petition is going off to another body. It's not coming to the BIA at all. Then absolutely, you're at liberty to sign on to support the perspective that you want and sign on to a petition to advocate to another body. Where we sometimes see members on bodies get themselves a little bit into trouble is if they've signed on to a petition, but the petition is coming to them and they are the deciding body. This happens when it's a member of council, for example, who signs on, or let's say it's a committee that's making a decision, an adjudicative body. They really, by signing on, would indicate to others that they've already taken a position, that they've prejudged the matter. And so we would discourage that kind of signing on to a petition. But in terms of signing on to a petition that's going off to another body because you're a restaurateur and restaurateurs of Ontario are signing on for maybe extending hours or what have you, you're not barred or restrained in any way from signing on to something like that. You're not doing so as a representative of the BIA. Presumably you're doing it as an individual restaurateur, and the decision is not coming before your body for any adjudication. Does that help?
Yeah.
Good.
Yes, thank you.
Okay.
Excellent. So we've covered, subject to, hopefully our discussion has stimulated some questions in your mind. We're quite happy to take them, or any kind of discussion that you wish. Before we conclude though, I do want to point to our contact information. And the only thing we ask is that rather than phone, it's helpful if you email us first and say, here's my issue, or can we talk? I'm available this afternoon at 3, and we'll do our best to set up a conversation. We like to do things over Zoom. Seems to be the most practical way to deal with things. But call if you must. And so
post office email is the best one.
That's right. This one is the best one. And we will send this deck along momentarily, and so you'll have all of this information. You don't have to scribble that down. So with that, are there questions?
I have a question. I have one, Jeffrey.
Certainly. I'm going to take the deck off the screen so everybody can see better, if that's
Sure.
if that's all right. All righty.
So this issue of bias that you talk about, that's always bothered me. And because bias is very subjective. So I don't care whether it's a member of council or a member of the BIA board or whatever, you're going to be voting on something and you're not, you're sort of entrenched in your position, and someone can accuse you of being biased, but you can say, oh, no, I'm keeping an open mind. Like, who determines whether in fact that person does have an open mind? And is willing to change their position, because it just seems very subjective to me.
So it's actually an objective test. And the test is that reasonable person test that Janice mentioned earlier. So the reasonable person test goes something like this. It comes out of Old English law. It's well established. What would a person fully informed of facts and circumstances conclude? So it's not a popularity contest. It's not what would the results of the survey be. It's what would the reasonable person, and that's us usually, we're usually in that position to be when we have to make a call on something. What would the reasonable person conclude about whether Councillor McKechnie is biased in these circumstances, if that was a concern? And there'd be input and discussion. So it shouldn't be perceived as a trap, because the starting point for the analysis is that, you know, you're doing your job, you're taking into account all of the facts and circumstances yourself when you're making a decision. It would be helpful for you to not do as Janice did before, to say, I'm putting up my hand and saying, I don't care what you say about it. You know, you're having an argument with the classic stupid person who you can't convince. Don't be that person. You do care what people say.
Mhm.
And it's not hard to discharge the perception that you might be biased by asking questions, by listening intently, by being respectful of people who are suggesting a different course of action. And you know, it's actually quite a rare event that somebody claims that a member is biased. We don't see it a lot. We'll see it described as conflict, but we don't see bias a lot. And let me just take that question and extrapolate a little bit. You'll see that in that list of family class, we went as far as first cousin, as saying, you know, if it's your first cousin who's the applicant and you know about it, there's a presumption that you can't discharge your public duty from you can't separate your public duty from your private interest, that of being your first cousin. And we'll acknowledge that, you know, maybe first cousin is a step too far, but it was the standard that was adopted, not at our recommendation, but by the city of Vaughan when Janice and I worked there and developed this conflict. And it came from public members who were sitting on an advisory committee to the code of conduct. They thought that was the limit. Clearview thought that was the limit. So that's the limit. And it's only when you know about the interest that you're technically caught by it. So there are a number of things that have to happen. You have to know about it. The person's got to be within the family class, and then you can always consult us for assistance on how to get through it. The harder questions might be on, you know, that one where your next door neighbor is involved, right? Your next door neighbor could be two very different people. Your next door neighbor could be your best friend, could be the godfather to your children. You go camping and fishing and whatnot with the guy every weekend. Or maybe when they're away, you pick up their newspaper and that's about it, right? So you're quite right. There is some analysis that has to be done, but the analysis is the reasonable person test. That reasonable person will be curious about the nature of the relationship. And because it's us, we have to make a call at the end of the day. And our call is going to, as much as possible, enable you to participate, because we don't want to exclude a member of the board or of council from doing their core job. But there may be times when it's a difficult decision. Janice?
Jeff, I'm going to jump in on bias and pick up a little bit on that. So we've heard, you know, from time to time, people will allege conflict of interest and or bias. And that's usually how people, if they raise bias at all, it's usually raised piggybacked on conflict of interest. And so we have seen that situation where, for example, a developer alleged that a council member was biased and never, you know, allowed, or all, I guess you would say, always refused that particular developer's applications. And, you know, we did a review, sort of a cursory review of the various applications and found, in fact, there was no consistent pattern of always refusing. So that would be one easy indication. I mean, it's a very high test to demonstrate bias. in court cases where from time to time individuals, parties will allege that the justice or the particular, when it used to be the Ontario Municipal Board, that there was from time to time an allegation that a member was biased. It's a very, very high bar. It may be it's an objective test. It may appear to the onlooker that it's subjective. It's a very high bar to really establish bias. I mean, it's basically establishing that the person is absolutely unwilling to ever decide in favor of a particular view or ever prepared to listen. And so it's a very, very high bar. I would just add one further thing, and that is that often on advisory committees, for example, I mean, in a BIA, the members are there because they have an interest, because they're in business in the community. But often with advisory committees, people are appointed because they have a strong interest in the matter. So, for example, an environmental advisory committee, those individuals are very likely appointed because they have some tremendous interest and probably some predispositions with respect to, a more green, more climate-friendly environmental perspective. And so you might think, well, they're bringing those interests to the table. Of course they are. That's the reason council in all likelihood appointed them there. Those are not biases. They are not disqualifying biases at all. They are simply the predispositions that those members have. So when they're looking at a matter, because often they're doing the heavy lifting at the front end to digest studies and information in order to make recommendations to council, they're bringing their interests, but one would believe that they are not biased. They are open-minded, although very much maybe leaning in favor of, ecological issues, etc. But people think that those sometimes are biases. No, they're not. They're their interests, but as long as they are not closed-minded to other information, that's the key.
Okay, thank you. And another question, if I may, and then I'll let the rest of you answer or ask some questions. But so, is it the town? If the BIA board member comes to you for advice, is it the township that pays? And you just, am I right that you just send the bill to the township, but you don't tell anyone at the township, the clerk or whoever, what the issue was? It was just, there's no details there. It's just basically that you were asked for advice and here's our bill.
That's correct. We usually just separate out conflict advice from code advice. From time to time, we will indicate, we used to indicate local board member, but we get so relatively few requests from local boards that unless it's utterly relevant, we wouldn't even identify that it was a local board request. So,
Okay,
and that's to reserve the confidentiality.
Okay.
Does anybody else have any questions or just any scenarios that you want to sort of walk through? I was going to say, maybe if we don't have questions, Jeffrey and Janice, it might be interesting for you just to give us a couple examples in very general terms of places where there has been conflict of interest in BIAs that we should kind of watch out for. Maybe something that comes up pretty often for you that is something that, we may not have considered, or, just, I don't know if you have any sort of examples for us that we might learn from.
Sure. I mean, I think the interest in common exception is more relevant to you. The one it doesn't apply really to local boards as much as to council members, but council members, as Janice indicated, are sometimes surprised that if they're a member of a body, that they have an interest that they have to declare. And so the question becomes whether they're a member of a body or not. At times we've interpreted, being a member of a museum board that's run by the municipality or something, well, that's not really a membership, that's a prepaid user fee. So we're generous in our interpretations. But if you're a participant and the directing mind of a body, then you're clearly a member of a body, and if you're paying dues to the body, and it's not a user fee, then you're a member of the body. The other area that people are surprised with are when their children work for the board or for the municipality. And so the MCIA catches them. And it's a little ironic. If you were discussing your own salary, there's an exception that says you can discuss your own salary, but there's no exception that says you can discuss the salary of your offspring. So it leads to a bit of peculiarity, and Janice and I intend to advocate for a change. But that, if your question is, what might be surprising, well, that's one area that takes a lot of people off guard. The interest in common area is one where you may want to posit some scenarios, because if maybe we should work on that street festival example I used before. So
I have an example. It's maybe I'm kind of airing dirty laundry here, but I own the community newspaper. I'm constantly struggling with where I can and cannot help out with the BIA, because I don't feel like I should be making any decisions around advertising dollars. It limits what I'm able to do on the BIA somewhat. So I'm not able to participate in marketing necessarily, that sort of thing. So there's an example of the kind of struggles that are very real for us. And I think many of us have that. We're such a small community. Sometimes as businesses, we're the only provider of that service within the community. We have a hardware store. If we choose to buy Muskoka chairs, and we kind of, in principle, as the BIA, always want to buy locally, is it in the interest of the home hardware that we buy them from them? So we are dealing with, it's such a small community. We're dealing with these things all the time. It makes all of us uncomfortable, and none of us want to, I believe this is such a lovely group of people, and we all have such integrity that we think about these things and we worry.
Yeah. Well, think about them, great. Worry about them, you shouldn't. Because there are mechanisms in place to have each of those issues resolved. And again, I know it's 1-800 call your integrity commissioner, but if to the extent that there's a gray area, we can help you work through it. At times, you have to step away. And from your perspective, you may well have a journalistic code of ethics that governs as well. So you have to look at it from both perspectives from time to time. But where there's a concern, using the Muskoka chair example, if the owner of the hardware store is part of the BIA board and they're making decisions, that person should step away from any discussion on where the chairs get purchased. Doesn't say you can't sell the chairs. If he's a member of the association and not on the board, then it's not an issue either. So there's a way to think through these concerns. And even if, I'll say this, even if there is no right answer, the answer we give is the right answer. So sometimes you've got these competing interests, and it's really hard to wrestle down what the call is. That's why we see ourselves as the reasonable person. We can give binding advice. The advice is binding on us, and so we will reason out a course of action. It'll be, in our view, the best course of action, and that's what you'd live with. So it's
Yeah, I want to just piggyback on that. I mean, that's an excellent point. At the end of the day, whatever advice that we give you, it's binding on us. We're the body that receives the complaints. At the end of the day, we know that if there is a complaint, we are not going to proceed on it. We will provide, if we've provided the advice that the member should do X, Y, Z, and the member does X, Y, Z, then if we get a complaint, we're going to down the ball, and we will write a disposition letter that explains why we're downing the ball. So we put ourselves in writing, not only with the advice to the member, but we put ourselves in writing back to the complainant. Here's why we're not proceeding on that. Here's our interpretation of the law. Here's our interpretation of those facts. Here's why we will not be proceeding on it. Now, a complainant who's not happy with that will go off to the Ontario Ombudsman. So we need to be clear. We need to provide a reasonable response. And, you know, we're trying to be correct. We're trying to be, you know, capture all of the facts and give an appropriate answer. But at the end of the day, in a sense, the buck stops here. But we know it can go off to the ombudsman. So we have to do more than just make an arbitrary judgment call. We have to be able to justify it and explain it. So we do that. We take it very seriously.
It's a good question, though, and it's the day-to-day sort of exam question you all are confronted with, but there's a path through it, and because our advice is contextual, it's important that we hear from you what the real circumstances are, and likely can advise on a path that allows you to participate to some extent on most of these questions. And for those occasions where you can't, that's a good thing to recognize that you're behaving ethically and just stepping away for the one matter.
Okay, thank you.
Ada?
I just have a quick question just to follow up on the councillors, Doug. So when we are seeking for help or advice, and you know, so as councillor said, so you build the township, but where is this budget coming from? Like, what is it impacting us as a BIA? Like, are we involved in the in the process of the payment, or is it just like there is some kind of a reserve from the township to support us and help us in this department?
Yeah, there's generally not a lot of money that's spent in local boards in any of our clients, you know, so it's not a big sum. It's not the advice, you know, an hour of our time is about $230 plus tax, so it's not a big hiccup from the municipality's perspective, and they don't know who is asking for the advice, so there is no way for them to bill back. There are times when councils ask us to tell them who has asked for advice, or a member of council will say, I'd like to pay for this advice myself. And we universally say, no, that's not how it works. It's important that everybody have the ability to have access to confidential information, and you can't start tilting that so some people feel that they have to pony up themselves. So there is no cost to you. I don't think it's likely that you're going to be reaching out a heck of a lot, to be honest with you. But you should know that the service is there and that it really can't avoid. It's an option, and like, don't take the risk if you think there's a concern, because the cost of a complaint investigation is astronomical compared to giving an hour or two advice. Complaints have to be done under the tenets of procedural fairness, and they need to be thorough, and it takes some time to write up a report. And so, you know, complaints can be very expensive. If it's a complicated complaint, it can be very expensive for the municipality. So don't be shy about asking for an hour's advice. Really, it is the way to go. And believe me, we're busy enough. We aren't, in all honesty, we're not shilling for work, but you are best protected if you have a concerning set of circumstances to reach out and say, what do you think? And we'll say, oh yeah, we got one of those. We did that last time. Let me write it up. Here's your answer.
Jeffrey and Janice, something that often happens, and Sarah sort of touched on this, is because a lot of us have stores, sometimes we end up providing things for events or whatever that we might need. And I think I just wanted to understand, if we provide something to an event, like for instance, I sell paint in my store. Well, sometimes, I don't know, maybe for these Muskoka chairs, or maybe for a sign that we're making for a festival, like I'm going to sell them the paint. But if I sell them at a wholesale, like, you know, am I able to do that, or should I just, yeah, it's so confusing. It's so, like, it's such a small thing, right? But it's like, sometimes it's just as easy for me to go get some paint from my store and paint the banner or whatever it is we're making. And then I could bill and what I've done traditionally is bill the BIA at wholesale so that I'm not profiting from it. Do you see that as like the correct thing to do in that case, or?
So technically you would have a pecuniary interest in
Yeah.
those matters, right? Even foregoing profit is a pecuniary interest. But the solution is not to participate in the decision making around it. So if you're now the act, I don't know who it is you're negotiating a price with if it's not going to the board. Even people that administer the BIA, you can't be influencing staff members to make a decision if they have delegated authority to make decisions. I don't, I'm going to be careful not to say you can do it because you have a pecuniary interest in something like that. But the focus of the statute and the code is that you should not be participating in the decision making when you have an interest. And as we said at the outset, it's acknowledged that you all have interests. You have interests every day in the dealings, but there are times when your interests will require you to step back from the decision making.
Okay.
Further to that, we all really like, it is kind of $10 here, $15 there, but we all feel, we worry about this. Is there anything that we can do at the board level to help our membership understand our board to understand how we can navigate this? Remembering also that our key, like our fundamental purpose is to ensure the health of these businesses. So the last thing we want to be doing is trotting out of town to buy something we could buy in town from our own businesses to avoid this conflict. Because remember, we have one store, we have one grocery store, so it really is a real issue. Maybe the other board members can tell me if I'm wrong here, but I feel it every time I'm trying to do something.
So we're talking about spending BIA money to do this, not your own, because I think there's a concept of remote and insignificant. And so a few dollars, a decision to spend a few dollars at a local store is not going to, even if it were a technical breach, it's not the sort of thing that it would be in the public interest to pursue. But it might be worth formulating a policy of some kind to talk about the limits of this, the expectation that from time to time it's going to happen, similar to a municipal purchasing policy, right? Which says that you can sole source in certain circumstances. There's nobody else available to do it. It's not a competitive thing. It's under a certain dollar value.
Okay, I think
there might be a way. Yeah, we can start with staff, but we can assist to help put something together.
That's what we need to do, because it's true. Sarah's right. Like we're so small and we do buy everything from each other. So that would be really good.
There's no way that when you've only, like, we've got 10 or 15 businesses in town, we have 8 people on our board, one of each owns one of the principal businesses. We absolutely are going to make decisions that will impact our businesses. So we need a way to manage this.
And sometimes we don't have time to really go to a board and do this, like when we're doing an event or something and we just need to purchase something, or we need to move on, do something, we just have to kind of go forward.
What's different is that in the municipal world, there'd be a council decision and staff would be implementing it. And staff would be making that decision where to buy the thing. And if the member of council owns the hardware store, then, well, that wasn't a direction given by council. Staff are doing that in the one hardware store town. Nobody's going to be exercised about it. What's interesting about your circumstances is not staff who are doing it, it's you're doing it yourself. And so we just want to think about whether that in any way, shape, or form is a decision by the board when you're doing it on your own. There may be a board direction to put a lot of money around or some expense policy that would govern, but it's probably not a board decision that would confront us. It's whether it's the policy framework that you have and whether you're complying with it. Okay. So if there's a need for a bit of a massage and a new policy, that's the way to go.
So you could have like a policy we could sort of base this around, like, I don't think any of us are really policy people. So
we can think about it. We certainly we can work with staff and think of something to put together.
Yeah, I mean, one thing that I'm just sort of, my mind is sort of spinning around, noodling around on this. If it's the case, for example, that there's 5 or 6 or 8 significant events that the BIA holds during the course of a year, and what is the budget upset on those, and how much of that do you expect to allocate to, the kinds of materials you need in order to roll the event out. Those kinds of things would be helpful if you're going to create a policy around that, so that maybe the board actually identifies in advance, here's generally the number of events we're going to target. Here's generally the upset limit that we're going to budget towards those and allocate towards those. And within that, so all members could participate in those kinds of discussions and decisions. And within that, if there's some guidance in the policy as to, provided the items are within budget or under budget or under the upset limit or whatever for the hardware, the materials, those kinds of things. It may be the kind of thing that the budget only, that the board only really decides on once when they look at it. And from that point, it can be implemented by the members. I don't know. I'm just kind of throwing that out there.
We already do that. So you're right, Janice. That's something we do. We set budgets for the various parts of an event. So, and then it's sort of at the discretion of that committee or that small subcommittee that's maybe managing that event to spend those dollars and not to go over budget and to provide their receipts and expenses back to the treasurer. But it just is, we just wonder about the conflict when it's just within town, like we're not getting quotes on things, printing, for instance, we print rack cards or we print brochures and, we print them within, people that sit on this board. And we don't go and get, a million different quotes and stuff just because, we want to support our local businesses.
Right. So, I mean, transparency is a great sanitizer.
Mhm.
So you thinking about these things up front and making those decisions is great. If you're talking about a budget and for an event and the hardware cost is part of it, you can parse that discussion so that the hardware store owner backs out of the component that deals with hardware acquisitions and can still participate in the grander thing. This is not designed. The whole scheme is not designed to prevent you from doing what you're doing. There are ways to get through it,
Okay.
Whether it's through a budget decision or a policy decision, or just making a determination that really it's a nothing. It's a de minimis concern in some circumstances.
Okay. Yeah. Okay, thank you. That's helpful. Any other questions from you guys? Or I know the first time I took this training, I sort of sat there not really knowing what to think a couple of years ago. And so I took some time to digest it too. So perhaps some of our board needs a bit of time to sort of think about it and digest it. And I know they might have questions later that they might want to raise with you, or just the idea that you're open and you're been so helpful to me personally, on various different items. So I think it's a really good service, and we shouldn't be afraid to reach out to these guys because they're super knowledgeable in this area. And it's just so nice to have somebody that has our backs really in the BIA, because we're out here as volunteers. We weren't trained as professionals in this job. We all have our own professions, and we're just doing this like kind of a volunteer hobby kind of thing to help the betterment of our community.
Well, it's heartwarming to hear that. And that's the way we want to be perceived. And so many integrity commissioners are the technocrats and seen as the sheriffs, and we're ready to bash people over the head. That's not our view. And the teacher coach analogy, I think, is the best one. So teacher has your best interests at heart, and they want to see you succeed. And that's pretty much the attitude we bring to our work. Yeah, some people every so often have to take a detention, but our overall approach is to help you get through some of.
It's really nice to know that we have that as volunteers, because we do worry. Anybody else have any final closing comments before we let Jeffrey and Janice get on with their evenings?
All righty. Well, thank you very much, and we'll talk to you again.
Thank you so much for joining us.
Bye-bye.
Take care, guys. Okay, so I'll let those guys just pop out of here, and then we'll get back to our agenda. So a couple things that we're going to do now, if you just have a few more minutes left in you. I know you've all had probably a long day. and it's coming up on, oh gosh, 8:45. But we want to talk about the budget, and we want to perhaps, be it that Sarah nor I don't believe any of us have had any sort of feedback or questions regarding the budget, we'd like to go ahead and approve the budget. And the reason we'd like to go ahead and make a motion and approve the budget is so that Sarah and I are hoping to go to council, because every year we have to go to council and we have to present our budget and have it approved by council technically before we really start spending it. And so the next council meeting that Sarah and I would be able to go to is April 12th, and our next BIA meeting is April 13th. So we would like to put forward a recommendation to the board now, if you're comfortable moving forward, is put a resolution together to approve our budget, and so that you would be instructing Sarah and I to stand before council, and Sarah's our treasurer, and present the 2021 budget as we presented it to you in the AGM. So there's a whole lot of wording around this.
Kayla wrote this up for me. Thank you, Kayla.
No problem. I do have a motion created here if you'd like me to read it and see if
Sarah and Kayla have been working on an amazing motion today.
No, it was all Kayla. It was honestly, I wrote something and she's like, how about this? This one.
yeah.
So
All right. So
yeah.
I can provide that for you and see if you have an appetite for the wording. Be it resolved that the Creemore Business Improvement Membership hereby approve the 2021 budget as presented and direct Chair Lori Severn and Treasurer Sarah Hershoff to present to Council on April 12th, 2021. And I will take the budget that was presented at the AGM, the minutes that we just approved earlier this evening, and attach that.
Sounds good to me. I'll
Are you
move
guys
that.
comfortable to move forward with that? Okay.
Yeah.
What we need
definitely.
is Doug's going to move it, and then we need a seconder, which we have in Jen. And then we have all in favor. This is a membership meeting, so Oda can vote for this as well. And Linda, you can vote too, because it's a membership meeting. I know we can't see you. You can turn on your camera. You're welcome to vote, because there's two different types of meetings, membership and executive board. This technically is a membership meeting because anybody could have come and listened to the integrity commissioner. That means everybody can vote. When it's a board meeting, or executive board meeting as they're sometimes called, that is just the board members that are appointed or elected. So that means everyone here can vote. Okay, so I think the motion carried. I know Linda doesn't have her camera on, but hopefully she agreed. I don't know. Okay, so let's move forward then. Thanks very much for that. Sarah and I will take that to the council and have that hopefully approved by our next meeting. And also I'm going to turn it over to Doug, who had a section he wanted to bring up in new business regarding stuff. So this is interesting. It's actually something I didn't know. I actually assumed it was not the case. It's about tourism in Clearview. And Jen, you might remember your conversations from past boards as well. I was under the impression that Creemore was designated as a tourist destination or designation or something in Ontario, and that we were allowed to open on statutory holidays. So that means Good Friday and Easter Monday and all these, holidays, Labor Day and such. Turns out we're not. We're not a tourist destination, but I'll let Doug speak to that a bit because now there's a motion in front of council to make us one.
Yeah. So thanks, Lori. So basically, Councillor Phyllis Deneen, she brought forward a motion at the last council meeting that, and I can't recall exactly what the motion said, but basically just to have all of Clearview made a tourist destination area, similar to Collingwood, Wasaga Beach and such, so that the retail stores can open at their discretion if they want to on the statutory holidays. And so anyway, she brought that motion to council, and prior to us passing a bylaw, it has to go to a public meeting. So they want to get it done prior to the May 24 weekend, so that if any of you want to open, you're welcome to on the May 24th weekend. So the public meeting will be held on April the 12th at our next meeting. And then the intention is the meeting right after that, which would be April the 26th. That's when we would pass the bylaw. So Lori and Sarah, I guess if you're going to be attending the meeting anyway to present the budget, so you're welcome to speak if you want then at the public meeting if on behalf of the BIA or yourselves. I was just wondering prior to like at the public meeting as a counselor, I can ask questions, but I can't give my opinion at the public meeting. I can give my opinion at the following meeting when we actually approve the bylaw or not approve it. So anyway, if anyone wants to talk to me and try and influence my opinion or whatever, then or has anything that they would like me to say, I'm open to it. But failing that, I think it would probably be a good idea if the well, I suppose it's up to you if the BIA board wanted to put forward a position of the board, and you can just present that on at the public meeting if you want, or in writing, and the rest of the BIA membership, if they want to, present their position, they're welcome to if they want to do it individually. So I just wanted to make sure that we had the timeline down properly. There was an issue there. I didn't think that you're, there was an issue there between Kayla and I on, on the timing of these meetings. So anyway,
I get it,
just
Doug.
wanted-
I was wrong. I admit it there publicly on YouTube, live stream this evening. I was wrong.
You could
Yeah,
go
and
Kayla.
Kayla, who was right? Kayla, you were wrong, and who was right?
I will get you a t-shirt made, Counselor McKechnie. You were right. Please do not tell my fiance.
Anyway, thank you, Kayla. So anyway, so I just wanted to bring that forward, let you know about that. So I don't know how you feel about it.
I feel like businesses have always opened whenever the heck they wanted to anyway. So I don't really.
Hilarious.
I didn't know. No, we didn't have it. So
That's my question. Like, I'm not. Excuse my ignorance, but I don't understand. Like, we were not allowed to open on statutory holiday.
no, actually, so if you are not considered a tourist designation on this, technically, like the May 24th, is it the Monday, Doug? That would be the holiday. I guess.
Yeah.
I guess in some world we could be fined for opening. Is that correct, Doug? To your knowledge?
Any business, or is it just
Any?
I'm not sure, Oda, I'm not sure if it's just retail businesses or whether it applies to restaurants as well, but and I don't know what the penalty is. I would assume that's a provincial thing. Doug Ford would have to come in and levy some sort of fine. I don't know. I haven't looked into it, to be honest. So.
And to be honest, I think during COVID, I think that's the last thing the government or the Ontario government would certainly be doing is running around to small businesses like ours and slapping them.
I don't want to open Monday anyway, but I'm just interested. Like that's like, isn't democracy that you can open whatever the hell you want?
Well,
I don't know.
yeah, I suppose, yeah. But, I agree with having a public meeting on this. You have to give the people, the employees a chance to say, look, I don't want to be, asked to come in and work on a statutory holiday. You have to give everybody a chance to have their say. But I think that's the way it's all going anyways. In my career, I think out of all the Christmases that I think I've worked about 30 out of 35 Christmases. And when I say I worked, I was away from home for like a week, over the Christmas period. So it was not like I just worked, 6 hours or 8 hours on Christmas Day. So, statutory holidays mean nothing to me anyway. They're just another day of the week. But anyway, that's, but you have to give everybody their opportunity to speak out on it. And that's why we'll have the public meeting. And I'll be honest with you, I think, I think council is very much in favor of Phyllis Dineen's motion. So, but we cannot show any bias. We have to keep an open mind until it comes time to vote.
That's right.
We are paying extra for people who are working, and we are also paying when people are not working. So I'm still not.
So true. It's true.
The
town I used to work in,
was a little bit
Yeah.
nothing was allowed to be open on the stat. Even the pharmacies, like if you were over a certain square footage, you were not allowed to be open. So if you were under a certain square footage, no problem, they would be open.
But I worked for a Shoppers at one point and no, we had to close. But the Rexall down the street could open. It was odd.
Yeah. Yeah.
So
Yeah.
I don't know. Yeah, no, I kind of agree with Oda. We pay people when there's a holiday and we pay people whether they work or not. So
But you have to pay them double time if they work and
Yeah.
holiday. So, but I mean, regardless whether you choose to do it as a business or not,
It should be up to you.
in principle, you can or can't. I mean, for a lot of us, it might not be worth it on statutory holidays, right? But
Yeah.
for others, it might be.
Right. So Doug, does it make sense
It-
right now for us to take a motion amongst the members we have here at the meeting so that you can go to council and say Creemore BIA supports the motion, or?
No, I think, you know what, Lori, I think it might just be better is when you come to do the budget, you'll be there about the same time as we do the public meeting. The public meeting always occurs at 6:30 or very close to 6:30 on the night of the meeting. So you may have to hang around for an extra 10 minutes or whatever, but it might be an idea if you put forward that the BIA supports it. Or I'll tell you what, if you don't want to hang around, just send me a quick email. Yeah, send me an email and I'll say that the Creemore BIA supports it. So
In order for us to support something as a board, I think we can only do that if we make a resolution at this table now.
Yes, please.
Any one of us can go to council to speak on behalf of the BIA if we haven't made that decision together.
I agree.
all right. So do you want to do a resolution now?
I'm happy to put forward a motion to support Councillor Deneen's
Okay.
proposal to put this forward. Kayla, help.
Okay, so I do have one prepared if you'd like.
Oh, teasing.
Be it resolved that the Creemore Business Improvement Area membership hereby support the proposed bylaw to allow retail establishments open on statutory holidays.
I will make that motion.
Right.
And who's going to second it?
Can
Jen's
I
going to
second it?
I guess you
Jen
can.
can second it.
Sure. And then where am I? All in favor. Sorry.
And Lori, if I could just say just before we end up here, just in case there's no confusion. I mean, the retail establishments do not have to open. You know,
Right.
it's up to them. It's just going to leave it up to them. You know, so if somebody decides, no, I'm still going to give my employees the day off, that's fine. They don't have to open at all.
Yeah,
So
thank
it's
you.
just
I
to
think
give them the options.
I think that's a really valid and good point to make, is if anybody's watching this recording, that certainly doesn't mean you have to open. So, right. Yeah, it's just, it gives people the options. And I think that's kind of nice, because I know that for us, lots of times we have opened and not known that it was illegal. So there we go.
Yeah.
Is there any appetite to add the words opportunity to open on statutory holidays to that motion? Is that
Yes.
there? Sarah and Jennifer is the mover and seconder?
Yeah.
Okay.
Yeah, the opportunity
Right.
to open. Yeah, I think that's a nice way to say it. Okay, perfect. So then, Doug, if you decide to speak, you can refer to the motion, or Sarah and I can if we're asked at council.
Yeah, I'll refer to it. I'll speak to it.
Yeah, I think it's a good thing to have, actually. Okay, so I think that pretty much concludes our meeting. Thanks for the special meeting. I know sometimes it can be kind of long having all these meetings, and probably once things get into the swing of things, we'll be back to our monthly meeting. But I appreciate all your time tonight. I know you've all had long days. So I saw Oda driving a giant cabinet, running behind it up the street today. So I know everybody's had quite a day in this board. So all right, so I think we can make unless there's anything else somebody would like to bring up, I think I'd like to make a motion to adjourn the meeting. Okay, so somebody here is going to make a motion. It's going to be Jen. And then I think Sarah's going to second it, and we're all in favor of it. So thanks so much. Have a good night. Sleep well.